Yes, right. Yeah, please. Right. Once if you come into the class, there is you have to take with you something, right? Yesterday in the previous class, please listen. In the previous class, we have seen the basics of mediation and conciliation, right? Again, it is recognized as one of the alternate dispute resolution mechanism. Right, it is also one of the alternate dispute resolution mechanism. Right. So, in arbitration, you cannot what is called determine the outcome. Here, the mediator or conciliator, he can change the dynamics, but he cannot determine the outcome. Result என்னன்னு சொல்லி conciliator சொல்ல முடியாது, but he can determine the dynamics. He can alter the dynamics basing upon the parties. Right? It is also recognized as one form of alternate dispute resolution mechanism. We have seen it is based on principles such as party autonomy. Parties are autonomy to choose the desired outcome also. The basic difference between please listen. Last learner. Right. In arbitration, arbitrator has power to decide the outcome. Here, he is not deciding the outcome. He will only alter the dynamics, methodology of entering into a amicable solution. Again, if it is not recognized under the Arbitration Conciliation Act, it cannot be recognized at all. This is even one form of alternate dispute resolution mechanism recognized under the Act. Right. Now we will see the difference between mediation and negotiation. Even though the terms appear to be synonymous, there is a difference between mediation and negotiation. Right. Here, negotiation is different, mediation is different. In mediation, third party enters the negotiation to assist the parties move through the negotiation process, right? Third party is entering into the process. He will make, you see, two parties go for mediation. third party is entering, he will make two parties to enter into negotiation and he will leave the outcome to the parties only. టూ పార్టీస్ మధ్యలో ఎంటర్ అవుతాడో ఇద్దరికి చెప్తాడు అల్టిమేట్లీ హూ విల్ డిసైడ్ ది అవుట్కమ్ దీస్ టూ పార్టీస్ ఓన్లీ డిసైడ్ ది అవుట్కమ్ ఇన్ నెగోసియేషన్ there is no independent dispute resolution practitioner assisting the parties to move towards the outcome. So this is the basic difference between mediation and negotiation. Here, mediation process is more structured. Mediation process is more structured. Mediation process is formal in nature. ఎలా అంటే అలా మీడియేట్ చేయడానికి కుదరదు. You cannot mediate as per your whims and fancies. There is a methodology for mediation. It is highly formal, highly structured. Structured and formal అంటే ఏంటి అంటే there are certain rules and regulations for carrying out mediation, right? And more structured and explicit than those of a negotiation. Negotiation is less structured, informal in nature. Mediation is different, negotiation is different. Mediation will go in a structured, phased manner, formal in nature, whereas negotiation is less structured, less formal in nature. Ultimately, whether it be a mediation or whether it be a negotiation, the desired outcome will be chosen by the parties only, not in the case of arbitration. You cannot choose the outcome in the case of arbitration. Arbitrator will adjudicate the entire thing, he will give you one award. There is no award in mediation, there is no award in conciliation. There is no such thing will be there. If you accept, you enter into an agreement. I will merely assist you. Depends upon permutations and combinations. You know the meaning of permutation combinations. Depends upon the rules, regulations, laws. I will make you to enter into an amicable settlement. If you accept for that settlement, you enter into the agreement. Once you sign the agreement, that is binding on you by virtue of your consensus added on. Right. Now, courts in number of jurisdictions, including Australia, US, UK, Sweden, and France, have held that agreements to mediate can be enforceable. In those countries, two things will be there. Going for arbitration, agreement is there. Going for mediation, agreement is there. Agreement is there. Whether you go for arbitration or whether you go for mediation, the agreement is enforceable. You are entering into an agreement. That agreement is enforceable. So courts in number of jurisdictions, including Australia, US, UK, Sweden, and France, have held that agreements to mediate can be enforceable. If you enter into an agreement to mediate, even though it is informal in nature, it is enforceable in the courts of law. You enter into a mediation agreement. If you go back from that agreement, the other aggrieved party can go and file the suit in the case courts to enforce that mediation agreement, where the process is set out with sufficient certainty, whereas the agreements to negotiate generally are not enforceable. That's why I told you mediation is formal, structured. So agreements to mediate is enforceable. Agreements to negotiate is not enforceable. Right. So there are many normative approaches which can be applied to resolve disputes in the context of mediation. A right-based approach focuses on There are different normative approaches out there. Normative approaches means your right based approach, legal rights based approach. You are having certain rights, legal rights, whatever. They are approaching this mediation as per your rights. There are different theories will be there, different approaches will be there. The not straight away you cannot what is called determine the mediation negotiation. There are certain approaches out there, evaluative approaches. For example, in criminal law, there is one concept is there, plea bargaining. Have you heard this? Plea bargaining, criminal law, plea bargaining. It's a very offense. Subsequently, he can bargain with the courts and the victims. He can bargain with the victim that please I will give some compensation. So courts will be liberal. Plea bargaining, it is also one of the methods of this negotiation or mediation. Plea bargaining. For example, you are coming to college. You are coming to college in a car. Suddenly, one cyclist was coming. You dashed that cyclist. Cycle, what is called broken into pieces. He filed a case against you. You go to the courts. You can bargain. I will purchase a new cycle, provided injuries don't happen to him. There is a system in the criminal also. Not only in civil mediation conciliation, even criminal law system also there is concept, it is known as plea bargaining. It is there. You give some compensation to the victim.